Welcome. The topic of discussion for today is media and entertainment laws in India. But before we begin, I would like to take the opportunity to introduce our guest for the day. With us is Mr. Faiz Ayad Ansari, who is an assistant professor of law at Parul Institute of Law, Vadodara. He pursued his LLM from Gujarat National Law University, saw qualified UGC NET examination and the Gujarat SET examination while pursuing his LLM in constitutional and administrative law. His interests in law include constitutional law, criminal law, comparative public law, media law, and intellectual property rights. He aims to contribute towards bridging the gap between the industry, policy making, and academia in the legal field. Recently, he authored a book titled Law and Justice in the Era of Globalization. Sir, I welcome you on behalf of Team Juris Minds. Let's proceed to the discussion.
The media and entertainment industry in India is something which is growing by the second. It is extremely robust and one of the few industries post the COVID-19 era, which we can really be to an extent proud about. Okay.
Yeah.
We can boast about it, kind of. Well, why do I say that? Because it is something which is not really saturated. It is still growing and there is still a strong foundation, strong backing for it to grow further. And the reason behind that is our strong diversity. Okay, when I say diversity, it means all the various kinds of diversities, starting from your geographical to your cultural, religious, everything. So through the entire length and breadth of India, this keeps us going, and that is why probably it is 35 billion plus USD industry as of now, with more than 1,000 satellite channels, your many D2H operators, and more than 1 lakh periodicals. So what more do you want? And it is still growing. It is not as badly hit in the post-COVID era as the other industries. Well, talking about governed by laws, of course, there is no one specific legislation which you can point out that, okay, this is the media law of India. Like it is similar to administrative law for that matter. You can't say that this is the administrative act. Okay. But still there are various sets of legislations here and there, which to an extent do govern. Okay, govern. I would stop short myself of actually using that word govern or regulate. I believe the appropriate word for the same would be to facilitate the industry, the entertainment industry. Such sets of regulations are required. And I believe, yes, there are legislations for the same. And I do think that there is a requirement, because why do I say that? Okay, there are many proponents, various scholars, various jurists, which you will find, who will say that there shouldn't be any laws to regulate, oblique facilitate, or oblique govern the media or the entertainment industry. But once you call it an industry, you are kind of portraying it more on the commercial aspects of it rather than the artistic aspects of it. Okay, so you are not limiting it to yourself that, okay, there are certain artists who are just carrying out their something which they like, rather than you are looking more of it on a professional side, so to speak. So there should be certain sets of laws, what I believe, and there are. All right, so when we talk about this fundamental right of speech and expression, where do we get this from? Of course, from the Constitution.
Yes.
Not meaning to say that there wouldn't have been any fundamental right of speech and expression had there not been a Constitution. It's a basic human right, so it doesn't really require any sort of a codification in any statute or constitution, so to speak. But since we are referring to the fundamental right of speech and expression, we are referring to naturally Article 19, Clause 1, Subclause A, when you talk that, okay, everyone has got a freedom of speech and expression, every citizen. Okay. But at the same time, those very fundamental rights, that very article is subjected to the reasonable restrictions in your 19 clause 2. And there are a whole lot of reasonable restrictions by the name of sovereignty of state, security of the state, public decency, morality, health. So strictly talking in terms of the freedom of speech and expression from where we are taking it. So from the same source, we are also having these reasonable restrictions, which may be applied equally. I'm not really actually advocating for the same in terms of its implementation, because as I told you that, okay, there's a list of 5-6 reasonable restrictions, but none of them have been defined. So that's where the problem is. Okay.
Yes.
Like what is public order, what is decency, what is morality? So that's where it is a little problematic. But certainly statutorily there are certain reasonable restrictions, and it doesn't really compromise ideally the freedom of speech and expression. Okay, Censor Board of India. So Censor Board of India is something which gets its again its statutory authority from a legislation called the Cinematograph Act of 1952. Now, okay, we call it the Censor Board. Officially, as per this act, it is the Central Board of Film Certification.
Yes.
That is the CBFC. So, unfortunately, I'm not talking about the layman. In fact, many law students or people in the legal fraternity as such, they take the meaning of censor as to stop something rather than to examine something or to assess something. Okay, so that sometimes ends up being a negative term in terms of its understanding, which it should not be.
True.
Now, coming to so what the Censor Board basically does, it certifies your films. Okay, it is called the Central Board of Film Certification. So its job is to certify the movies. Okay, not in a blind manner stop some movie from a release. So as everyone is aware that there are various categories of certificates, where U, UA, A, and the S or X category, whereby depending on the age, the Censor Board gives it a certificate that, okay, it is fit for release in so and so for so and so public. So it is one thing to actually be fine with the idea of censorship. Okay, so that is a debate in itself, whether there should be censorship or not. And once you debate about it, and once you are fine that, okay, some sort of a censorship is required, then you go on to your step 2. That is the body which is there to implement the censorship, that is the Censorship Board. So there are 2 steps to it. Okay, if you are fine with the first one, only then you go ahead with criticizing or analyzing the role of the Censor Board. So what I believe is that, Censor Board is not an absolute negative concept in itself, but implementation or the objective implementation rather requires a lot more to be desired. I would opine that unfortunately it is both too strict and too lenient. That's the problem. If it errs on one side, you can still, let's say you are a film producer for a moment, or you're a film director, or some big large conglomerate which is into the movie production business. Okay, so once you know that, okay, this is the Censor Board, there is some kind of constant behavior which it follows over a period of time, you can plan yourself accordingly. I'm strictly talking here in terms of business view. Okay, I'm not going into the debate of freedom of speech and expression and the artistic way of looking at it. So, but the thing is that sometimes the Censor Board is too lenient. When I say that, I mean that there are many movies which you would find which are blatantly spreading communal hatred. That's it. That are blatantly just targeting some caste or some community, or sometimes some religion as well. Okay, and when you are saying that there should be reasonable restrictions, okay, which are there in the Constitution itself, So you talk about public order, decency, morality. So is that decency, is that morality? Even though these two terms are not defined, I have my reservations that some of the movies which are given a clean chit, whether they should be given or not. I'm talking about the central theme of the movie itself. I'm not talking about XYZ scene of 2 minutes or 3 minutes. All right. And when you say that sometimes it is too strict, what I mean to say is that, uh, as you may be aware, at the okay, it's fine to put up a warning that okay, so and so thing is harmful for health, or so and so thing should not be carried out, or only meant for people of XYZ age, whatever it is. But once any sort of a, let's say, a smoking scene or a drinking scene, once it's there in the middle of a movie, so I'm just taking this example, there are various other examples. Okay, so if such kind of scene is there in the middle of a movie, it is, if I may try to put it in a very very generous manner, it is not really intellectual on the part of the censorship authorities to put up a disclaimer right in the middle of a movie that okay, right at the bottom of your screen, with no one damns to even read, but still it's there as a part of it. And I'm sure most of the viewers must be thinking that okay, why are you telling this time and again, why are you infringing our right of freedom of speech and expression? We want to enjoy the movie. Okay, you have given some kind of a warning to us which we were okay unaware of, that it smoking causes this or drinking causes that. I'm not advocating here for smoking or drinking. I'm just telling you is the freedom of speech and expression at this point of time. So that is where it is perhaps a bit too strict. And there are various areas, others examples also, which I'm not really discussing because it's the central idea which matters more. It's very interesting co-production treaties actually. So because it involves elements of both, of course, media law fundamentally as well as international law, which also fascinates me personally to a great extent. So co-production treaties in today's era are basically what you call bilateral treaties. Okay, there are rarely many conventions which come up for co-production. There are by and large bilateral treaties where India, let's say, enters into a bilateral treaty with Japan, with some European nations. A few years back, I believe in 2014, India entered into one with China as well. Okay, so this good old concept, like the concept in itself related to the movies, that is kind of new. It is quite contemporary, where two or more countries, they enter into a treaty to kind of pool their resources, their know-how, their workforce, and try to expand the ambit of their movies into each other's territory, basically. But even though this implementation is quite a late phenomenon in terms of the media, in terms of the movie industry, but the fundamentals of it are quite old actually, because at the end of the day, it talks about pooling of the resources. Now, if you have a look at way back in, from 1947 itself, in terms of the Indian scenario I'm talking about, if you have a look at the Constituent Assembly debates, Dr. Ambedkar, of course, not in terms of the media law, but he talked about the pooling of resources in terms of environmental law. Okay, so the natural resources be distributed equally among the people, and then came your directive principles of state policy, kind of furthering that approach. Okay, talking about the international scenario or the jurisprudential aspect of it. If you quote Jeremy Bentham when he talks about your utilitarianism, maximum benefit to the maximum number of people, that fundamental concept is being used here in the movie industry. Okay, so this is something which owes its origins to something very fundamental in nature, but it is very very important in today's era, and actually more so important for the Indian movie industry. Like, why do I say so? Why is it more important for India? Is that as you may be knowing that the people of Indian diaspora, they are pretty much spread across the globe more than any other country. Okay, and that is why you see various so when you pool the resources, when you enter into such treaties with, let's say, an Australia or a Poland, you will find Indian diaspora there, and somehow it's an inherent thing in the DNA of Indians, I believe, that once they are away from home, they become even more, nationalistic, and okay, it's our movies, so on and so forth. And if so, and one of the results of this positive results of this treaty, you can find that recently, even though right now we are not in very very friendly terms with China, but of late, if you see in the last few years, Indian movies have started doing really, really well in China, which was not traditionally a really stronghold for the Indian movies. They always did well in your Europe, in your North America and your Australia, but not there. But that is the reason, because in 2014, this treaty was signed, and more screen space to the Indian movies now in China. And so it's more, more important for India than any other country. Yes, they should definitely lay more emphasis on the right to privacy. When you talk about privacy, of course, it's not that it's a newly found concept. Okay, we've been talking about this particular right from our 70s, from our 80s only. There was this good old case of Khadak Singh, which every law student must be remembering, where of course it was not mentioned in the in the majority judgment, but still a dissenting judgment did lay down that privacy is a fundamental right which should be respected. And of course, needless to tell that in recent judgments of last 2-3 years, it has been concretely laid down by our honorable Supreme Court as a fundamental right. Now, when you take this concept of right to privacy and kind of import it into the media law scenario, it's kind of a dichotomy. Because media, at the end of the day, what do you mean by media? Media basically means it's a medium, it's a mode of dissemination of information. Okay, right. Which is to an extent an antithesis of privacy. So what happens is that the journalist, I'm not going into the debate of whether deliberately or out of their ignorance maybe, but some over enthusiastic journalists, they don't really get the difference between how much information you have gathered as a journalist and how much of that information should you publish. That's a fine line of difference between the two. And of course, what few people from the journalist fraternity and a few legal scholars as well, what they opine is that when you talk about the right to freedom of speech and expression, it is a two-way right. And of course, I agree with it. It's a two-way right in the sense that it is your right to freedom of speech and expression to disseminate the information. But at the same time, it is my right to receive that information. Okay. So giving out information and receiving information. So what a few journalists, they kind of overdo with the second one, that, okay, we are not, it won't compromise our right if we don't disseminate the information. It will compromise on the rights of our viewers, of our readers, if they don't get to receive the information. But at the same time, there is something established called right to privacy, which has got its elements both in 21 as well as your 19 also. So that is where you need to respect privacy. And there are a number of judgments of the Supreme Court as well, where it has criticized the media for overdoing it, over enthusiastically peeping into the lives of people totally unnecessarily. Like if any case is going on, let's say, I remember way back when there was this IPL franchisee at that point of time, Kochi Tuskers Kerala. So the then co-owner of this particular team, Sunanda Pushkar, she was the co-owner, and there was some issue, some controversy regarding that team, regarding the finances of that team. Now, what many media houses unfortunately did, is that they peeped into her personal life, the way she lived, the way she dressed, where she went. Now what on earth has all this got to do with a financial issue? Maybe whether it is or not, that's a matter of investigation. So it's a vague example which I remember because being a fan of cricket or sports law in general as well, so this example comes to my mind right now. But so that's the thing, when it is totally not at all connected to the issue in hand, to the matter being investigated, you peep into the lives of the people, you infringe their privacy. And the very, very unfortunate thing is that an overwhelming large majority of the viewers, they don't criticize it, they don't take it as seriously as maybe you or me will do. So that's an issue. So that needs to be sorted out, both at the legislative level, like as you said, that should there be more stringent application of privacy laws, both at that level as well as the societal level. My opinion with respect to online defamation and maybe the need for some new law is kind of something which is unpopular, because the popular opinion goes like we need a new set of rules and regulations, if not a full-fledged legislation, at least some policy to begin with respect to online defamation and to cater to it. But I believe that defamation is one crime which is quite unique, because both your civil law and your criminal law caters to it. So the law of torts talks about this particular crime, and as well as 499 of the Indian Penal Code, it talks about defamation. Now, the thing is that the IPC in itself is sufficient enough, as per my understanding, to cater to online defamation.
Okay.
And as an addition to that, you also have got your Information Technology Act 2000, which laid down a framework to cater to this particular crime. Now, the thing is that we haven't been able to properly implement both the IPC as well as the Information Technology Act. And unfortunately, the large majority of the people in this country, they tend to be, they tend to be a lot more emotional, and they think that, okay, if we come up with some new legislation, new set of laws, or if we make the existing provisions even more stringent, then that will definitely be something which will address the issue for right now for our discussion, the issue of online defamation.
Right.
But the fact of the matter remains that it is the certainty of the implementation of the law which stops the crime from taking place, which stops the civil wrong from taking place. It is not that if you come up with an extremely deterrent piece of legislation, which the criminals know that it is never going to be implemented, that won't work in a society, right? So, instead of going more onto the quantitative aspect of it, that okay, we need more laws, okay, quantification, we need more stringent laws, so instead of 3 years, increase the punishment to 5 years, 7 years. So instead of overdoing with the deterrent theory, the deterrent theory is fine, I believe in it, but look at the way you are implementing it. The implementation needs to be certain. It should not be like, okay, one fine day, if you think that okay, it should be implemented, that should be implemented, otherwise you are not going to implement it. There should be an amount of consistency, and consistency in the application of the existing law, I believe, is sufficient enough to cater to this problem of online defamation, and nothing more is required for it, I believe. So when we talk about media and entertainment law, as you asked the first question to me, that what are your thoughts on the industry, on the entertainment industry in India, it is growing as ever. And whether you take it as a bane for the society or boon for the lawyers. Whatever you take it, it is actually something which will make for more opportunities for lawyers. So if you want to make it, talking from a career point of view, if you want to go into litigation, it's a really good field to be into. If you want to go into policy making, if you want to be in academics, it is again ever evolving field of law. Law in general is very dynamic and it is ever evolving, but media law more so. And specifically with the dynamism of the industry as such, and it not being limited to India and becoming more contemporary as ever. Because if you see in the post-COVID era, there's a very interesting development that even the movie releases are not now going on online platforms.
Yeah.
Your Amazon Primes, your Netflixes, your Hotstars, etc., etc. So the interesting legal issue which I see developing, not saying that there wasn't any online platform before COVID era, right? But now it has skyrocketed, the importance of the same. So one important issue which I see emerging is that when you talk the question regarding to censorship, whether it should be there or not, etc., etc., etc. So this entire concept of censorship, the Central Board of Film Certification, it is meant to certify the movies for theatrical release. Okay.
Right. Yeah.
Which essentially means, strictly talking as per the legal provisions, the movies which will be released on the online platforms, and not only movies, let's say various drama series which have been released on online platforms, they are not subject to the same censorship laws. Okay.
Right.
Now, the thing which is quite interesting, I'm not here advocating that there should be extreme censorship. I'm just telling you that there seems to be a discrimination in the application of the laws for movies which are releasing traditionally in your theaters. Okay. Now, this contemporary issue, okay, you may say that there you can control who actually enters the theater, and therefore you can, as per the certificate given by the CBFC, you can make sure that only XYZ people watch the movie. I'm not taking into account the piracy issues here. I'm not talking about all that. Okay. So ideally, if it's a utopian scenario, you can say that we are catering to that issue. Do you really mean to say that all these online platforms are not in the access of children? I have my reservations on them. So there seems to be a lack of consistency in the implementation of these censorship laws, which is a very contemporary scenario, especially in this post-COVID era with the movie releases also going online. So this is something very interesting, and yes, it remains a very interesting area of law. It's really fascinating, and so that's my thoughts on it. It's really it's very contemporary, it's really futuristic as well, and there's a lot to look back as well into the history of the media, in the evolution of media from your ancient ages to the medieval era. So it's really, really interesting. It's really dynamic.
I would like to thank Professor Faiz for taking the time to converse with us. It was a pleasure.